Hello, everyone, and welcome to our webcast, what is in fact a special, breaking in some senses webcast, Julian, in relation to the third tranche of industrial relations reforms that have recently been introduced into Parliament by the federal Labor government and Minister Tony Burke. Join me with me today is Julian Arndt, one of our most recent director in the Sydney Workplace Relations practice at Australian Business Lawyers. Julian, welcome.
It's a thrill. This is the hottest ticket in town. It's the biggest story in town, so it's going to be a fun hour.
It is a thrill to be here to talk about the reforms with you. We had a webcast initially slated for later in September, but we have obtained this slot to specially cast to all our clients, New South Wales Business Chamber members, and friends in relation to what is a very, very long list of reforms that we are staring down the barrel of.
The phrase you're looking for is overwhelming public demand for this webcast. So here we are. You asked for it, we're here. So let's roll.
All right. There's a whole range of topics we're going to talk about today. They're all up on the screen now in terms of the slide. I won't mention them one by one. We're going to go through the details of each category of reform. Going to talk about some of the key talking points, and then probably most importantly, a little bit of Julian's hot takes or my predictions as to what actually we think is going to happen here. What's the prescient lesson, or what we can expect, or the big change that's going to have an impact on employers and employees alike. And we'll kind of try and keep to that format for each change. No need to furiously scramble the slides down. I think they will be accessible after the presentation. Julian has the trusty iPad with him for questions that you can post live throughout the discussion, and we will endeavour to answer the questions as they pop through. I think that's probably all the introductory housekeeping. It looks like I've left something off.
No, well, if we go to the next slide, there's a lot to talk about. But if you go to the next slide after this, we are still in the realm of the theoretical. So the bill was introduced on the 4th of September. The feeling was, and I think the intention was, that this would all be, whatever phrase you wanted to use, pushed through very quickly. Now that hasn't happened. The Senate voted to delay the progress of the bill. So what we're actually looking at is a Senate inquiry process, which will end in February next year, which seems a long time away. None of the changes that we're going to talk about are necessarily certain. It's still subject to parliamentary approval and process. The sense we get is a lot of the ideas are pretty firmly held, and so they'll sort of be pushed through. But it gives us a bit of latitude to give our hot takes, give our prediction, and who knows, maybe we'll get some feedback on the iPad about how things might tweak or how things might be fixed.
Yeah, and it's the important thing to remember is that the government holds, once it aligns with the Greens, I think it holds all the votes it needs in the Senate bar one. So we're talking about one crossbencher vote being required. You've got to assume that the bill won't go through exactly as is today, but what will be required to tweak to get the vote of one crossbencher? Last time it was David Pocock, could be someone else next time round, but that's going to be the challenge the government has to get the bill through. But what we do know is there's going to be a big bill passed early next year. It's going to have a lot of this kind of stuff in it. I'm going to lead off. With two topics: casual employment and employment generally, employment versus independent contracting. Some very big changes in this space. And we're really been on quite a journey here when it comes to casual employment. Some of our viewers will recall that if you rewind 5 years ago, the test pertaining to casual employment had always been one determined by the common law. There wasn't a statutory test. There had been differing approaches taken broadly between the Federal Court and the Fair Work Commission. The Commission more looked at how someone was engaged and paid, were they called a casual, were they paid a loading. The Federal Court had taken somewhat of different view, looking at the overall substance of the relationship. This reached a head with the Workpac and Skeen and Workpac and Rosado cases. The High Court ultimately landed on a test that very much focused in on the terms of the contract in determining whether a relationship was casual or not. That was then codified, if you like, in the Fair Work Act itself. One of the very few amendments to the Fair Work Act made, or of any substance made by the coalition government in its terms, 2 terms, was to introduce a definition of casual employment. And no sooner did it settle into the drafting of the document that we now have a new definition being proposed, one which is very different. The key elements up there that you'll see, firstly, there needs to be an absence of a firm advance commitment to continuing indefinite work. And secondly, the employer needs to basically be entitled to a loading of some kind on the understanding that they're a casual. But most importantly, when looking at that, whether there is an absence of a firm advance commitment to continuing indefinite work, the court or a tribunal must now look at the real substance, practical reality, and true nature of the relationship, having regard to not only the content of the contract, Julian, but the mutual understanding or expectation between the parties, which may be inferred from conduct during the performance of the contract. What we're talking about is a regime whereby regard is going to be had to a range of matters regarding the relationship, and some of them that the Act expressly directs attention to are now up on the slide. Is someone able to elect to offer work or reject it? Look at the employer's enterprise, interestingly. Is it likely that this type of work will be available in future? Are there other people who are on a full-time or part-time basis performing the same kind of work? That's a really interesting one, because you often end up with scenarios where employers will have lots of permanent workforce, but then a flex up, flex down, or a surge workforce with casuals. And that the fact you might have permanents doing it might actually go against you. Is there a regular pattern of work?
I mean, what we're saying is the contract is no longer king or queen. We're looking at the true substance, the true nature of this relationship, which is kind of, and it's a very helpful background, historical background that you gave. We're reverting to that kind of analysis as opposed to merely looking at the words on the page. And it's intentionally trying to do it. This reform is intentionally trying to go back to the real substance of the relationship as opposed to a contract.
And I think that is going to pose some problems for employers, because there is less certainty at the commencement.
Can I put to you the problem, and then maybe you can fix it? The problem is this, isn't it, viewers at home, is that if we're talking about the true nature and I can't rely on my contract, well, how do I know when the casual is just sort of formally morphed into a permanent? Well, they've given us an answer in the legislation.
Well, they have. So there is now a choice process that's being introduced into the legislation, whereby employees, after 6 months or 12 months for a small business, can elect or effectively notify the employer that I don't think I'm a casual anymore. I don't think I still meet that definition. There's been some changes that mean that I actually don't look or taste or smell like a casual employee anymore. And the employer can only reject that choice of election on limited grounds. They are reasonable business grounds. That is, they can no longer, or they can't on an ongoing basis accommodate that pattern of work, or if there is a law of a state or territory pertaining to the engagement doesn't permit it to be moved as casual, or the employer can validly demonstrate that they don't meet the permanent employment definition under the Act. So there is now this choice that's been added on top of existing casual conversion laws. But the piece you're referring to, Julian, is what the statute now has, which it never had before, is a reference to the fact that once you have been identified as a casual on commencement, you cannot morph unless a specified event has occurred. And what I mean by that is that the legislation says that once engaged as a casual, you effectively need to either be converted under these new regimes to do with choice, which enable the employee to elect to point out that they've morphed, and the change of status will only happen after that process. There is the other existing casual conversion process, or by agreement, you've agreed to move the employee to permanency. So what that means is the employee will remain a casual at law indefinitely unless there is one of those three specified events, which obviously the employer will know about it happening. And so what we will see is that there won't be this unwitting conversion to permanency. There won't be an employer inadvertently engaging someone under a pattern that magically at some point the employee becomes permanent and no one knows about it. And that was the problem we had under the WorkPack litigation before the coalition government reframed the laws. And that problem is now addressed with these specified event laws. All you need to worry about is ensuring you get the engagement right on commencement.
Yeah, it's the compromise, right? You aren't stuck as a casual forever merely because that's what your contract says. But equally on the employer side, you do not lose sleep at night, assuming you got the contract right, thinking those people, they've magically become permanent and now we should be paying them annual leave. That's not how the legislation works. It's based on triggers, it's based on applications, it's based on orders. And then once that status changes, everyone knows that it's changed.
And so, as Julian said, the really critical element is getting it right at the beginning. At the beginning, you won't have 12 months of pattern of work or 6 months of pattern of work to look at. It will be, what were the circumstances on day one? What was the contract that was formed? What was the nature of the business? What was the nature of the work? And it'll be confined to that. And as long as you get that right, that will be the yardstick till there's a trigger event. And I think that provides some certainty for employers. I think in the grand scheme of things, when we know that the Labor government went to the election with a commitment to change the casual employment definition, I think during the consultation process, there was a lot of concern that we would end up in a land of uncertainty. And I think where we've landed with this bill, there's still some headaches, but it's nowhere near as bad as it could have been. And there's some comfort I'm taking from the way that the provisions are currently drafted.
You're very positive about the development, Lewis. I certainly agree with you that there is a technical certainty. No one's going to be any doubt whether you're casual or permanent, assuming you get the commencement right. There may be an operational uncertainty though, because employee choice, it will always be in the employee's arsenal to make the election to flip over. So in that sense, it's no longer certain. You can't set and forget after writing a contract. Businesses will have to deal with the operational uncertainty of these people. They're not permanent now, but maybe they could be.
Yeah, but we all actually do have casual conversion laws at the moment. Obviously, that still operate. The employers still need to go to the workforce after 12 months of 6 months regular engagements and say, you have a right to convert, do you want to? So it's simply building on a mechanism that already exists.
Last thing I want to say, everyone wants to know about back pay, because that was a big part of the whole Rosado thing, that there was this clawback provision. Back pay shouldn't be an issue under this regime, should it?
Because even if they have morphed into a different form of employment, they now look like permanent. They won't formally transition till you're notified of it. And the other helpful thing is there's a transitional provision which says if the employee would have been casual under the old laws before the reform, they are deemed to be casual on commencement of these reforms. And again, that means their status can't change without a trigger event.
That gets a big tick from both of us.
Employees versus contractors. I think whilst we've been somewhat positive about the casual reforms, I think a lot more pessimistic and a lot more concerned about these reforms. A new section is proposed to be introduced to the Fair Work Act, where the assessment of whether someone is an employer or contractor will be conducted by ascertaining the real substance, practical reality, and true nature of the relationship between the worker and the principal. The Act will expressly state that one must look at the totality of the relationship between the individual and the person, and that regard should be had not only to the terms of the contract, but also to other factors relating to the totality of the relationship. What this means is the freshly minted High Court authority of CFMEU and personnel contracting, which restated the principles of how a person is to be characterised and placed primacy on the contract between them, is shredded, for want of a better phrase, because you now are not only looking at the terms that the parties have agreed, but how the relationship has unfolded in practice. And critically, What we're missing with this is what we've got with the casuals, which is a level of certainty. Even if someone's relationship changes, you don't have this scenario under the casuals where their status can morph without you knowing about it, and where they would go from worker one day to employee the next. In this case, that can exactly happen. Someone can be under a contracting relationship, things can change as the relationship unfolds, and all of a sudden, the next moment, they're employees. There's no protection in relation to that, only being able to happen if a specified event occurs. And so I think we end up in a world of uncertainty where we're back to assessing the multi-factor test.
The walking like a duck, smelling like a duck, swimming like a duck, trying to work out, is this an employee on the whole? Is it a contract? That's what the test requires you to do, to assess the true nature of it. Personnel contracting and Jamesh, that little high court period that we had, absolute certainty because you just looked at the contract. Shredded or binned or whatever you want to say, it's done now, that era. So we go back to what we had before those cases, which is very difficult questions on occasion to determine whether someone's an employee or a contractor.
And you have to balance all the different considerations, all the factors, and one person may form a view that, well, when you've juggled all the balls in the multi-factor test to ascertain whether they're an employee or a contractor, one person may say, well, they've fallen in the employee box, another the contractor box, and it's that uncertainty that that means that employers will probably face some exposure here to liability. Unfair contracts.
Let's roll through this quite quickly. So there is a new ability being introduced into the Fair Work Commission to review terms of service contracts. So if you think about it, most of the Fair Work world is to do with employees. This is broadening it out, and it broadens it out in a number of other ways into the world of contractors. It only applies to a limited group of contractors. So there's some text on the screen about how the jurisdiction works, but not all contractors will be caught by this new ability to review their contracts. But I think the critical point is they must earn below the contractor high income threshold. I don't know what that is. It's not because I haven't read the text. They haven't informed anyone what that is yet. So it seems very important to me what they're going to set that contractor high income threshold at to determine what this new jurisdiction will mean.
And look, the other interesting thing is right now, independent contractors of this nature, so that is where it's predominantly being performed by an individual or a director of a company or their family members, they have the ability to bring these claims now under the Independent Contractors Act. They just simply haven't been doing it. In the last 17 years, there's been very scarce usage of the Independent Contractors Act. It will still operate for claims by people who earn above the high income threshold. So there's still going to be an ability to bring these claims if you earn above the high income threshold under the Independent Contractors Act. It just simply hasn't been used very much. What remains to be seen is once this jurisdiction's kicked over to the Fair Work Commission, will there be a greater propensity to bring these kinds of claims, or will they actually just be not very utilised as they are, as is the current scenario?
The answer has to be yes, doesn't it, Lewis? I mean, the Fair Work Commission surely is a more accessible jurisdiction for the type of workers we're talking about.
I don't know about that, because you can't just go and get compensation under this type of claim. You need to go and establish that a term of your contract itself is operating unfairly and have it varied or voided or amended in some way. Not just that someone did something unfair to you, not that they dismissed you unfairly, that the term itself of the contract's unfair. And I just think that it's narrower scenarios than people may think that are going to capture this, perhaps.
We're going to have to see. We're just going to have to wait and see.
The next regime that's been talked about a lot is the gig working regime. It's probably received a disproportionate amount of focus given the proportion of the economy that involves these businesses.
People are interested how much their pizzas and cheeseburgers are going to cost. Like it's a very popular thing to talk about, but it's an interesting new jurisdiction.
Yes.
Take it through it.
So effectively, if you are an employee-like worker, and again, an employee-like worker, the starting point is an individual who's mainly performing the services under a contract, or they're in a company where most of the work, the work is done by a director or family member of a director, or a partnership where the work's done by the partner. So it needs to be the individual performing the work. If they fulfill that definition and they meet one of the triggers that are in that second bullet point below, they either have low bargaining power, they earn REM at or below the rate an employee usually earns REM, they have a low degree of authority, or any other characteristics that the minister might prescribe from time to time, then they can bring a claim where they are engaged to perform services through a digital labour platform operator. Now, digital labour platform operator is effectively an operator that engages independent contractors through a digital software application. But what's critical is not only are they using a software application to engage these contractors or arrange for this engagement, but critically, they also aggregate the payments that the independent contractor is owed for the purposes of them paying it. So we are talking about your Ubers, your food, menu logs, those types of apps which facilitate engagement, but also aggregate payment through the software to then pay it out to the worker. So you need to meet all of those requirements. If you meet all of those requirements, then a union or you can bring a claim to the Fair Work Commission to seek a minimum standards order. And that minimum standards order is going to operate a bit like an award, but for contractors. It's going to set out, or it can set out terms about payments, deduction, working time, insurance, consultation, all the things in the yes column on your slide, none of the things in the no column. And it will effectively operate as a minimum standard for contracts with that type of worker.
The point of this is that the jurisdiction is designed for workers who are employee-like. So they don't have the benefit of modern awards, but they're not, well-paid, strong, built up enough to have all of these negotiating rights. So it's a safety net for those workers. Very interesting, the types of things that they're thinking about putting in minimum standards orders and the types of things that they're not. I think this is a bit of an appeal to the nature of the gig economy, that you don't necessarily want to be telling gig workers or gig worker engagers how to roster or necessarily dealing with overtime. But you do want, so the claim goes, you do want minimum standards in terms of what they're going to get paid, how records are kept, insurance and so forth.
And so these will be set by the Fair Work Commission. The Commission will also have an ability to ratify collective agreements for these workers. So companies may agree collectively with the workers to a set of terms and conditions, and provided those collective agreements are more beneficial overall than the minimum standards order, they can be ratified. The next piece of this legislation is that there will be an ability to arbitrate unfair deactivations. Now, deactivation is defined in the Act as a scenario where effectively a worker's access to the software is suspended or terminated or otherwise modified such that their work is either stopped or their ability to work is effectively stopped. There'll be a 21-day filing limit for them to bring this claim, and it's effectively an unfair dismissal jurisdiction for gig workers. It operates very similarly. The Commission will consider whether deactivation was fair, and it will also have regard, the Commission that is, to the Digital Labour Platform Deactivation Code, quite a mouthful, which will be set by the Minister by way of regulation, which will set out the things that must be taken into account in determining whether a deactivation is fair or unfair. It's effectively an unfair dismissal regime for gig workers. Few questions that I think you want to probe.
Yeah, so my thing is, in this space, the employers, the operators are incredibly sophisticated outfits. There's a reason why this industry exists. There's a reason why this new form of gig work exists, because you have very sophisticated operators seeing a gap in the market and filling that gap. They will do something to respond to this. I'm very interested to see what they do. I have a theory that maybe they see some goodwill and some progress in actually going after collective agreements as opposed to just being subject to minimum standards orders. So that's interesting. There's already been some movement from some operators on that front. The deactivation remedy is interesting because I'm not sure you can get you can't get compensation for being deactivated. You just get reactivated, and I think you can get some lost earnings. I'm wondering what they're going to do with the algorithm, how they're going to. I'm not sure that anyone but them knows how the algorithms work. So precisely working out whether someone's being deactivated or how.
You get preferred suppliers, non-preferred.
It's very, very interesting.
Necessarily get deactivated.
The last point I'll make is, will the models change? Like, will the type of operators in this space just say, okay, well, we'll stop processing aggregated payments and we'll just make money some other way? Very, very interesting. I don't know the answers to any of those questions, but you would have to say that this regime, while protecting the employee-like workers in the space, it's going to have a cost consequence, you would think.
You would think, and it'll be interesting to see whether there's significant change here. I think there's a big desire to keep the deactivation remedies. I can't see the collective agreements being a problem, so that'll probably stay. So there might be some tinkering around with the definitions or what can be in a minimum standards order, but I suspect this is the type of thing that's probably going to remain relatively static and come into play as law relatively unmodified from the draft that we're currently looking at. You've got a commencement date there for all of these changes. There is quite a long lead time. Some of them don't commence till July next year, some November. Some of this could change depending how long it takes to get made law, but certainly there's no sense that anything's happening immediately. So there's time for everyone to get across the detail. Speaking of getting across the detail, one of the big changes relates to same job, same pay, which is no longer called same job, same pay. It's called closing the labour hire loophole.
In my house, it's called same job, same pay because I think that's what it is. The reason why I'm not going to engage in the closing the labour hire loophole parlance is because it applies to more than just labour hire, as I understand it, and as I think most people at home will understand it. So let's talk about it. Let's talk about it. Same job, same pay. This is aimed at protecting bargained outcomes. So the idea is if a union or a group of employees negotiates an enterprise agreement with their employer, it shouldn't be the case that that employer can somehow get out of that bargained outcome by outsourcing work or creating some kind of shadow labour hire workforce to do the work not subject to the enterprise agreement. So that's the idea. It's very broadly drafted. And the reason it's very broadly drafted is because those kind of arrangements are very complicated at some level. And also, some outsourcing arrangements are, so the argument goes, worthy of being captured by this idea of aimed at protecting bargained outcomes. So the technical phrase is regulated labour hire arrangement orders, which can be applied for. They have to be applied for. This is probably the most significant part of all of this, is that this same job, same pay doesn't just happen by magic or doesn't just happen by the stroke of the Parliament's pen. It happens after an application and a Fair Work Commission order to that effect. What would a regulated labour hire arrangement order require? Well, it would require an employer providing labour to a host to pay the applicable rate of pay under the host enterprise agreement. It's a very broad test. It's an extremely complicated test, but the gist of it and the actual, the higher level test is it's fair and reasonable. And hosts and providing labour are drafted very broadly. We're not just talking about labour hire companies providing workers to hosts. We're talking about one employer providing a worker who will work for, with another employer,
including possibly an outsourcing.
Correct. We'll get to that. Here's the long list of factors. Lewis is very, very keen to have this list in there, but I don't think we can kind of go through them all. We use the phrase, what something smells like, in some of these tests a lot when we've been discussing this over the last few weeks. I mean, this is a very broad scope of tests that the Commission would have to apply to come to a view whether it's fair and reasonable to apply the bargained outcome on someone who's not covered by the enterprise agreement. I love diagrams, so let's go through this one. So just so everyone understands what we're talking about, we've got an employer supplying a worker to a host. That host has an enterprise agreement and it's got coverage for the work of that employee. The union says, we want to get that employee paid under the enterprise agreement. The question will be asked, is it fair and reasonable? If it is, a regulated labour hire arrangement order will be made. And what will happen? Well, the enterprise agreement in relation to the pay rate only, will start to apply to the employee. Now, that's an obligation on the employer supplying the worker. It will obviously have ramifications for the host as well, because they're paying the employer supplying the worker for that worker's services. It can apply to service contracts, Lewis, and this is really, this is probably the most interesting part of all of this. It's not just labour hire providers providing to hosts. It can apply to work which is provided under a contract where it's wholly or principally performed for the provision of a service. So that could be an outsourcing scenario. It could be.
Entirely. And so if the Commission's going to apply these laws and issue a regulated labour hire arrangement order on a services contract, it will need to consider the involvement of the employer in the work. And when we say the employer, that is the outsourced provider, if I can call it that, whether they direct, supervise or control the employees, or whether that's done by the host, whose equipment is being used to the extent the work is of a specialist nature, and the extent to which the host employs or have previously employed or could employ people to who the enterprise agreement applies. So let's take a very topical topic, say the Qantas outsourcing of its baggage handling. I think had these laws existed at the time, the Fair Work Commission would look at all of these things and say, well, this definitely should probably apply, because the involvement of the employer is a matter that could likely be subject to some debate, but one would assume in the case of the actual conduct of the baggage handling activities, a lot of it done at premises that Qantas holds a license to operate at. You've then got whose plant equipment's being used. I'm not across all the detail, but assume a lot of it would belong.
Actually, reading the High Court case which dropped yesterday, I think that might actually count against your argument here. But anyway, go on.
Well, and it could be. So this maybe it isn't definite, because it could be. You'd have to look at who actually is owning the plant or system. The last one certainly would weigh against Qantas is the fact that they have done the work historically, previously, and that it's been outsourced. So, that's an example of how it would be weighed up. And you would really get into the reeds of both who's directing and supervising how the work's done, but also the question about the premises, who's got the license to use it, who's got control of the premises, and same with the plant and equipment.
There are so many touch points to this test, because it's meant to work in a way where the Fair Work Commission can decide, is it fair and reasonable that these people get paid the bargained outcome that was made at scene?
And obviously the end point is, the greater the control the host has, the more likely it is there's going to be a tendency towards granting the order.
The more strategic and cynical the move, the more likely it is that you may face a same job, same pay order. That's not the technical name. I shouldn't have said that. It's really important to understand this is only going to give rise to an obligation to pay a protected rate of pay. It's not going to just magically make the enterprise agreement cover you, or that you have to apply all the terms of the enterprise agreement. There's some very difficult questions to answer in relation to what precisely is the rate of pay and what precisely is the conditions of the enterprise agreements, and there's some overlap there.
It is the full rate of pay, though. It's not the base rate. It's the full rate of pay someone will get. So that includes loadings, allowances for the work they perform. It's all the monetary entitlements.
There's an offshoot of the jurisdiction where you can get an alternate or an alternative protected rate of pay, where the protected rate of pay is unreasonable. Maybe it's too high, maybe it's too low. Again, we're talking about a jurisdiction where the Fair Work Commission will be making a broad assessment of what is fair and reasonable, what is the rate, what is happening here in terms of these complicated business arrangements, and should we get a bargained outcome and apply it to employee? Is that the fair and reasonable thing to do? So here's the talking points. It's by application only. So this is absolutely critical. This will only happen if someone makes a claim for it and wins a case for it.
Again, this is another win through the consultation process. My take on the consultation process that we saw the papers being issued by the government is they weren't necessarily looking at something that narrow initially. There were concerns it could apply at large. You wouldn't know whether you're caught, whether you're not, what rate you have to pay, you will definitely know if you're caught or not, because you're going to get an application served on you before any of these liabilities are triggered.
And that means, in terms of trying to work out who the likely targets are and the scale of all of this, I mean, it really comes down to union priorities and union resourcing to see how many cases they can run, how many targets are going to be made, and anyone watching will have a few sort of likely targets in mind, possibly targets where there's some media campaigns being run against them. But it'll be interesting to see. It's not going to apply to everyone, which I agree with you is a huge comfort for a lot of people.
And there is a long lead time, not going to kick in for another year and a bit, November 2024.
Although I think the applications can commence once we get the law, but the obligations will only kick in November. Speaking of the obligations and the long lead time, the anti-avoidance provisions apply on the current drafting, and assuming the bill gets passed, from the date where the bill was introduced into Parliament. The reason why that is because anti-avoidance is just making sure that people can't take steps to avoid the operation of these provisions coming in. The point of that is so that all the employers out there who are worried that they might be subject to same job, same pay jurisdictions or applications, they don't take steps to get rid of those workforces, so that the very people who these laws are meant to protect do get protected eventually when it comes in. Certainly, I imagine a lot of people will be seeking some advice about this particular issue if you can just feel that warmth of the spotlight starting to shine upon you. The road transport regime, this is a very, very important subject to us.
Well, our firm, for many of you may know, specialises in the owner-driver jurisdiction, road transport engagement regime, acting heavily in the three regulated jurisdictions, the New South Wales Industrial Commission, the Victorian Small Business Commission and VCAT thereafter, and the Western Australian Road Freight Tribunal. We do a lot in this space, and the space is about to change markedly. So there's going to be a road transport expert panel set up and a road transport advisory group. That's not too much to talk about. That's basically just saying when the Commission, Fair Work Commission, deals with road transport matters, it'll be a special expert panel of members that deal with it, and they will have regard to advisory group input when they deal with award conditions, so on and so forth. It's just about a specialisation within the Commission, not too much to see there. There will, however, be a new ability for the Commission to make road transport minimum standards orders for regulated road transport workers, and I'll come back to that concept in a moment. It's a bit like the gig economy orders that we called minimum standard orders as well. It can cover the same things as the gig economy orders. And so again, we're going to have these awards effectively for contracting relationships, setting out some minimum standards, which is very unique for a contracting relationship to be regulated in this way. The interesting part of this is that the laws do say that they do not override the New South Wales and Victorian jurisdictions. So we don't know whether the Fair Work Commission will interfere with the existing regimes, particularly in New South Wales, where we have general carriers contract determination, courier determinations, redundancy determinations, mutual responsibility for safety determinations. There's all these determinations already that apply to road transport contractors in New South Wales. The Fair Work Commission could ride right through all of that. It could copy a lot of that. It could seek to supplement it. We're just yet to see how the New South Wales regime, and in particular, is going to be supplemented by these federal standards orders. In addition to the standards orders, there'll be collective agreements that can be made. Again, this is not new to the New South Wales regime, but it is new to most of the rest of the country. And there'll be an ability to arbitrate unfair terminations for road transport regulated workers. Now, these road transport regulated workers are very similar to the gig workers in terms of definition. Again, there needs to be a services contract involving an individual. So it is either the individual performing the work. If it's a PTY limited company, it's a director who's doing all the work, most of the work under the contract, or a family member of the director. Alternatively, if it's a partnership, it's a partner doing the work under the contract. But we're talking about a contract with an entity where there's an individual performing most of the work. Additionally, they need to meet the high income threshold for contractors. Julian didn't know what it was 20 minutes ago. I don't know what it is now. There's a real question as to whether it will align to the employee unfair dismissal threshold or whether it will be different. As you can imagine, cost inputs for contractors are different. And so there may be an appetite to have a different threshold. But having said that, the threshold is going to be the same for gig workers. And for gig workers, I think there is a real desire to keep this to the vulnerable few. So
I might just pick up there because it is very, I mean, the way that the Act's drafted, these two, road transport and gig work or employee-like work, they're sort of twins and they run along, and a lot of the provisions apply equally. They're so different in terms of those two industries. The employee-like worker industry regulate or operated through the online platform, the aggregated payment, that world, and the world of road transport, which really does affect so many parts of the economy. The sophistication and the cost of running of some of these road
barriers to entry, low barrier to entry for gig economy, massive barrier to entry in terms of road transport because you're buying a prime mover worth a couple of $100,000.
And that's not absolute. Not everyone in the employee-like worker space is going to be a uni student delivering food, and not everyone in the road transport space is driving a massive truck. But they are very, very different. And I think the road transport changes are probably the sleeper issue. One, because of the incredible importance of road transport. Two, because a lot of it, not in New South Wales, but a lot of it has just been left to sort of run itself, and imposing a lot of regulation will have effects. But the last point there is interesting. There's a new power for the minister to introduce laws regulating the road transport industry contract chain. Now, I don't know what that will be used for. So that
seems to be an interest in the actual beneficiaries further up. So we know who the big transport companies are. We know they're bound by these instruments. I think there's a bit of an appetite to go further up to the big beneficiaries. Two of the biggest beneficiaries are Coles and Woolies for a start. All of their product is effectively distributed by road. And I think so there may be an appetite to extend to them. The unfair terminations operate again like an unfair dismissal jurisdiction. There'll be a question as to whether the cessation of the engagement is harsh, unjust, or unreasonable. There'll be ability to be reinstated or to award compensation of up to 6 months' pay. I think we've talked about most of these talking points. The only one I'd particularly like to call out is the long notice periods for the issuing of these orders. So from when the Commission issues a notice of intent that it's going to issue a minimum standards order, the order cannot take effect for 24 months. So it's going to be a long lead time.
I think that's a concession to, the Commonwealth Government has not been in the business of regulating road transport. I think that's a concession to getting involved is a big step, and it's going to cause a lot of questions, cause a lot of heat. They need a long lead time because otherwise the process could potentially
and if you look at that, these laws don't commence till at the earliest 1 July 2024. So the first order that would effectively take effect is at the very earliest, well, it wouldn't even be July, but you'd expect it would be 1 July 2026 if a notice of intent is issued from that day. Wage theft.
We've got a crime on our hands. We've got a crime in our practice now. Look, wage theft has been coming for a long time for the Fair Work Act. It's going to be here now. Under the new provisions, an employer commits an offence if the employer was required to pay an amount, and so under an act or a Fair Work instrument, so you've got an obligation to pay, and the employer's conduct results in an intentional failure to pay the required amount to the employee in full on or before the day when the required amount is due for payment. Some things are not involved in the wage theft jurisdiction: super, long service leave, jury or paid emergency services leave. But we now have a crime if you intentionally fail to pay something that's due and owing. The penalties are pretty serious, very serious, really. 10 years jail. The fines there are eye-popping. Interestingly enough, the maximum fine is, there's two roads you can go. You can get 3 times the underpayment or the very high penalty unit calculated fines there. This is a very serious jurisdiction. Obviously, not every underpayment is actually going to be prosecuted because it has to be prosecuted in the criminal system. But this is a new development which brings to bear some significant talking points. The first one's your favourite.
Yeah, so there was a lot of that. We've been talking about wage theft for a long time, and people will remember that the former coalition government was actually going to regulate in this space. And there was a big level of anxiety about how reckless or negligent underpayments would be dealt with and whether they would be criminalised as well. And I think there was certainly a desire on the part of many through the consultation process to see that happen. And I think quite thankfully that has not happened. And so there is no criminal offence for reckless or negligent underpayment. There still will be a civil liability and you can be subject to civil penalty, but not criminal sanction. I think that's really important because it does ensure people that inadvertently, for whatever reason, underpay are not facing jail, even though they need to fix the underpayment. So I think that's another win that employers have got through the consultation process. I think that it is a sigh of relief that people can breathe because it could have been, and at one stage I thought was going to be much worse. So I think credit to the Australian Chamber of Commerce, to Business New South Wales, and Australian Business Industrial, those have been advocating through the consultation process to ameliorate some of the worst parts of these provisions. They've succeeded, and I think we should be pleased for that.
So, but there remains the technical breach, Lewis. So all we need is all this needs to be is intentional, right? Potentially, if it's intentional and underpayment, potential wage theft. Now, I'm no snitch, but I know of employers, and definitely I've spoken to employees over a moderately long career who have indicated that they know that technically something is meant to be paid at a certain point, but for whatever reason, usually because it makes more sense not to pay it at that side, for everyone's purposes, they don't pay it. There's a number of examples you can think of. There are some set-off arrangements where you work a lot in 1 month and technically you're probably underpaid against an award, and then in the following months, you kind of make it up. There's scenarios where people do not pay on termination, the termination payment that probably is due and owing for whatever reason. This is something that employers need to understand, that the game has changed. I know you're not entirely convinced about my excitement about all this, but I tell you who will be: the unions, in terms of the leverage that they can apply in an argument about wages, in an argument about interpretation, in an argument about if this person did not commit serious misconduct, you cannot summarily dismiss him, and if you do not pay him notice, you will be committing wage theft.
Look, I think it may be a bit over dramatised, Julian, because I think
we've got to give something to the fans. Come on.
I think that the reality is that for most employers, if they intentionally underpay a sum of substance, yes, you're going to have a problem. If you intentionally withhold notice, of course you're going to have a problem. If for some reason there has been a technical breach and you haven't resolved it yet, but you intend to resolve it and you're going to ensure the person's being compensated, etc., whether the Commonwealth DPP is going to consider that as something that falls within their prosecution guidelines, completely different question. But no doubt the upshot of all of this is where you know something is not compliant, you do have an obligation to rectify it, or you do have an obligation to ensure you pay in the right manner, because if you don't, it's a more serious offence.
And let's not be flippant. I mean, wage theft where it's intentional and it's materially detrimental to the employees, it's a really serious thing, and it's been taken really seriously by the government. So there are a lot of laws that are crimes that don't get prosecuted. So maybe my slightly dramatic point can be met with that. Delegates and union powers.
Yes, I'll deal with this quickly because I think we want to get to some of the questions. So there will now be a process for exemption certificates to be issued to allow unions to enter without notice where they're seeking some kind of access to the premises to investigate contravention of the Act. People can get excited about this. The reality is unions can come on to inspect safety breaches without notice right now. So the fact they can get exemption certificates to come on, I don't think it's going to change the world. If they want to cause trouble, they've been doing it through safety breaches for the last decade. So I just don't see this as a huge change to the norm. The other change, which is much more significant, is universal delegate rights. Delegates will be able to be granted a right to represent members in dealing with disputes with their employer. That does not currently exist. They're also entitled to reasonably communicate with union members, and they need reasonable access to the workplace and workplace facilities to represent their members, reasonable access to paid time during normal working hours for training, unless you're a small business. I'm just going to repeat that. Union delegates will get reasonable paid time off by the employer to go to a training nominated no doubt by the union for the purposes of furthering their delegate training or delegate duties. This is really interesting. There's no definition of what reasonable access is. For some business, in fact, I think there's considerations. I'll go to the talking points, but for the Act sets out some considerations of what is or isn't reasonable by reference to the size of business. There is no number of delegates who get this confirmed. There's no amount of training days confirmed. I mean, the other thing is we need to be frank here. Most of these delegate training sessions, opportunities to go to the yearly union conference, the local piss up, if you want to call it that, for a particular union. I mean, no one begrudges them the ability to go and convene. The problem is that this is now being paid for by the employer, and I think that is a problem if it is not contained or constrained in a way that's clear and is measured. And we don't have any of that yet. We may in time, but we don't at the moment.
So I think it's going to stabilise somewhat in that in modern awards, there will be a requirement to have delegates' rights clauses. What they'll say, how prescriptive it will be, I'm not sure. Once those are in modern awards, enterprise agreements will have to have, by reason of the boot, a delegates' rights clause that is at least, equal to what's in the modern award. The reality is a lot of enterprise agreements already have delegates' rights clauses. A lot of enterprise agreements already have paid time off. So these things are going to stabilise. It doesn't apply to small business, so we're not looking at small businesses paying for their workers to go on union training camps. We're talking about a particular type of employer. We're talking about modern award setting expectations. We're talking about bargained outcomes. So I don't think it perhaps will be as loose as some of the fears out there suggest, to keep banging the drum on your inspection without notice thing, which you say happens anyway. I mean, I'm very interested by that because, again, with the new introduction of wage theft, the idea that a union can come to a site without notice to inspect a possible underpayment breach, and the threat of that underpayment breach being a criminal offence, it's scary. That is much more scary than if it wasn't a wage theft. If there was no wage theft, then if there was no inspection without notice. So these kind of things they kind of multiply on each other.
I think we do want to get to questions, so we might
let's just run through bargaining because this was the biggest story out of the tranche one.
Yeah.
Multi-employer bargaining. Basically, it's no criticism whatsoever, but they've sort of tweaked a few little arrangements around how bargaining would work with the multi-employer bargaining streams. There are some new arrangements about how you can replace a supported bargaining or single interest agreement with a single enterprise agreement. It's quite interesting for people technically interested. The boot will be applied against the existing agreement and not the modern award, which is very interesting. Normally the modern award is the baseline. There's some franchisee changes which are interesting. This is one for those on the web who have to get their enterprise agreements approved and occasionally have to incorporate model terms into their agreements because they've forgotten to put them in or because their existing terms weren't quite up to speed. Now the Fair Work Commission will be writing those model terms and not the minister, and they're under the regs. So
but there's no suggestion of new model terms. It's just that the responsibility for the content has gone from the minister to the commission. So
we might have an interesting case talking about what should go in them, or we might not. But nothing massively to be concerned about. But speaking of the Fair Work Commission, tranche 1 set up this idea that really the focus of this system under the Labor government will be the commission.
And that's undoubtedly confirmed now by tranche 3. So we're not going to go through all the bullet points there, but basically in relation to all of these laws, a large chunk of how matters are determined, how rights are set, how rights are arbitrated or disputes resolved, is all in the hands of the Fair Work Commission. And so the Fair Work Commission is going to have a much greater role in wage setting, in dispute resolution, than it has ever had in its existence since '09. And what that's going to see is actually a far greater use of lawyers. We're going to have greater litigation. Industrial relations practitioners are licking their lips in some senses. The one thing the government, employers have noticeably been somewhat concerned about a number of the reforms. I can tell you, employment lawyers, it's like Tony Burke is their best friend, because there's just more and more reforms leading to more and more disputation. There's going to be a much greater role for lawyers in this regime, and it's just a consequence of a number of ways you can litigate under each of the new provisions that have been introduced.
Which comes back to this essential compromise by the draft of this legislation. Yes, we're going to change things to allow employees greater rights, protections, and so forth. But generally, where we can, we're going to make those rights contingent on some kind of application or decision process, push it over the Fair Work Commission. You know, as you say, employment lawyers need to rock up and argue those cases. But that's the compromise. We're not clicking our fingers and changing everything for everyone. We're going to allow these avenues, but you need to win the case, and it's going to put a lot of strain on the Fair Work Commission. I think they're up to it. It's a great institution, very, very well run and organised and modern, and the feedback is good, but they've got a lot on their plate.
All right. Well, we've got a few questions that Julian's going to rifle through.
People are interested in the casual conversion process or the casual choice. If casuals convert to a permanent full-time position, can pay rate then be reduced to remove the casual loading?
So my understanding is yes, they're not going to get the casual loading and the permanent pay rate. They will remove to the permanent pay rate for their role minus the casual loading.
And I have to say, that's why a lot of casuals will not change over. And
yeah.
that's what's happened with the casual conversion regime. People don't change because they don't want a reduction in pay. What's the difference between the right to request casual conversion and employee choice?
That could be a terminology issue. So there's currently an obligation on employers to offer casual conversion. Broadly speaking, where someone's been employed for 12 months and the last 6 months of that have been regular and systematic. That remains, that obligation to offer casual conversion. In addition now, though, employees at any time, subject to having been engaged for 6 months, regularly and systematically, or 12 for small business, can elect at any time to simply convert. So it's a small deviation from the employer offer regime. It merely complements or adds to it.
Question after your own heart. Will the new powers in road transport override what happens at the state level?
Remains to be seen. I mean, they don't at a legislative level. The state laws continue to apply in at least New South Wales and Victoria, not necessarily WA. WA was not subject of a carve-out. But what remains to be seen is whether the Fair Work Commission will delve into New South Wales and Vic and issue its own instruments that will apply as well as or on top of or instead of the state regimes.
Maybe one more question. Are there any interaction with time in lieu arrangements, formal or informal, including in relation to the wage theft legislation? Is it now better simply not to have time in lieu arrangements and pay salary and overtime when incurred and applicable? So time in lieu always brings up a lot of issues.
Yeah, I mean, this comes back to Julian's obsession with technical breaches and that people can be in prison for 10 years for something.
Abiding man.
But I mean, this is a good example, though, of where you might be doing something informal that doesn't quite technically align. You need to clean this up. Does the award have a time in lieu arrangement? If so, are you complying with it? If the award does not, and if the award says someone is to be paid overtime for Saturday or Sunday work, you need to be paying overtime. You can't just supplement your own arrangements unless that is something permitted by the award. Now, most awards do have time in lieu arrangements. The problem employers have is they might not adhere to them strictly. It's about getting your process correct and aligned to what the award permits.
If you need any help with that, we are here. I think we're pretty much out of time, but what else can we do?
So how can we help? So one, we're obviously across all of the new laws going on. So happy to take any questions on this. We are also assisting various employer organisations, including BNSW and ABI, with feedback on the reforms. If you have specific feedback through Business New South Wales or ABI, feel free to use those avenues or contact us direct, and we can try and facilitate that. We've got alerts that are coming out on the reforms, so you can identify them on our website or subscribe to our mailing list. And other than that, I think we will be back with another webcast towards the end of the year. I think that's it. So thanks, Julian, for the time. Thank you, everyone, for listening. And